Okay. So we are live. This is Senate Judiciary, Monday, June 22nd, 2020. We're taking up an amendment to the bill that is just been posted to the website. It is draft 2.3.
It's 1.3.
I don't have that on the website yet.
Yep, I'm posting it right now.
Is it
All right.
what you emailed to us, Brian?
No,
No.
minor change. We could
Oh,
start
okay.
all right, well, why don't we start over? Not the committee, but looking for the. I've still got 1.2 on my judiciary website.
And just to be clear, it's 1.3. The only difference is a corrected cross-reference.
Okay, well, why don't we start on A and then assume that we'll get
Okay.
start on the intent language and assume that we will get to C by the time we get to C that a new, or by the time we get to the second amendment, we will be at the.
Sure thing. So for
Okay.
the record, Bryn Hare from Legislative Council, and I'd be happy to just talk about draft 1.2. I could just point out where draft 1.3 has been corrected.
Okay,
Otherwise, they're identical, so it's really no problem to look at draft 1.2.
Okay.
So this is an instance of amendment that would add a new section A1 to the beginning of S219 to add some language about legislative intent. There are two subsections to this section A1. And the first sort of lays out that the intent of the General Assembly is that this S219 is a continuation of the work that the General Assembly has done over the last several years on legislation that addresses systemic racism and a disproportionate use of force by law enforcement. And then it lists several acts, which I can go through. 2017 Act 54, that was the RDAP bill, Racial Disparities Advisory Panel. 2018 Act 9, that was the act that created the Executive Director of Racial Equity. 2013 number Act 180, that was the act that was about the statewide policy on the use of force, or the training requirements for electronic control devices and the use of those devices by law enforcement. 2016 Act number 163, that was the model state policy for the use of body cameras by law enforcement. And 2017 Act number 56, that's the professional regulation of law enforcement bill. That also references S338, the Justice Reinvestment Bill, which doesn't yet have an act number because it's not quite done winding its way through the process. And it then at the bottom of the page there on page 1, lines 20 to 21, there's language about how there's legislative committees that continue to work on these issues. So this act really represents just a part of the legislature's ongoing effort to deal with these issues. Subsection B on page 2 sets out the intent of the legislature that law enforcement use community policing strategies and practice a guardian mindset towards the citizens that law enforcement serve, and establish a culture of transparency and accountability that will both promote public safety and foster the public trust. And then the last sentence there is, to this end, it's the intent of the General Assembly that law enforcement use de-escalation strategies first and foremost before using force in every interaction with the community.
okay.
So,
Any questions or changes or comments about this good work?
Yes.
Very clear.
So
Alice,
I just wonder if we could go to line 3 in section A and stop the sentence at put a period after use of force, period, rather than saying by law enforcement in Vermont. I don't know that we really
I'm
have
sorry, where are you?
on line 3 in section.
Actually, it's line 8
It is.
in the draft I'm looking at.
So the sentence reads, it's the first sentence in A.
Oh, law enforcement agent, it's on line 4 in the, in
Okay,
of the General Assembly, law enforcement agencies in Vermont. You want to,
I want to drop that. I just wanted to end with disproportionate use of force.
I'm reading, I'm sorry,
New-
Alice.
The new draft is on the committee page.
Yeah,
I don't know if that makes a difference. but-
Printed this one a few minutes ago. So what's your first sentence, Dick?
on line 4, page 2, it's the intent of the General Assembly that law enforcement agencies in Vermont use community policing strategies to develop collaborative partnerships between law enforcement and communities, adopt policies and practices that reflect a guardian mindset towards the citizens they serve, and establish a culture of transparency and accountability to promote public safety and foster public input.
Dick, I think
Dick?
Alice is on section A1A. So the very start of it.
Right. On line 8, I believe, is where Alice is.
The version I have doesn't have any line numbers.
All
but
right.
Right.
So you want the act as a continuation of the General Assembly's work over the past several years to create meaningful reform to address systematic racism and disproportionate use of force by law enforcement, and you want to strike in Vermont.
I want to, and disproportionate use of force, period.
I
Rather
don't know
than,
why you want, I can understand taking out Vermont, but I don't understand taking out law enforcement.
all right, by law enforcement. Okay, then take out just in Vermont.
Alice, can I ask what your rationale is?
I mean, I think this sends a very bad message that we have a lot of disproportionate use of force going on here. And while we have some, I think this sends a message to the entire country that we have a lot, which we don't. We have some, that's for sure.
Well, I can see that, but I guess the other way to look at it would be it's owning what we do have. It's saying in Vermont, we do have this problem.
I think it would take care of it. I mean, I think we don't have an excessive problem in that area.
I would be fine with taking out in Vermont because, that's understood that we're legislating for Vermont. I think it's important to keep law enforcement.
That's fine. Keeping law
Yeah.
enforcement is fine.
All right, I think there's general agreement to take out in Vermont.
Okay, I'll strike that.
Anything else on that, on the intent section?
Mm,
Okay, shall I move on to the second instance of amendment?
Yeah. And because Matt's not here or not able to change, I'm going to read from his email to us.
I think he's on his way.
All right, well, I think what I'll start with is, I know that I didn't express myself well on this today because I didn't really see it coming and had to work from memory. But in taking a closer look at this, which is the section that we're proposing to amend, doesn't implicating the entire justifiable homicide statute as a defense effectively got the use of force provision that you're referring to in S219. The first paragraphs 1 and 2 deal with lay people, not law enforcement. And if you read this together with the new language in use of force, doesn't 3 still let the officer off the hook if he or she is suppressing opposition in a just and necessary discharge of his or her duty? If you needed to get the bill out of there today so it wasn't going to argue with Bruce, Philip, I think there's an issue here. just something to think about. See highlighted portion. And the highlighted portion is in the case of a civil officer or a military officer or a private soldier when lawfully called out to suppress a riot or rebellion, or to suppress an invasion, or to assist in serving legal process in suppressing opposition against him or her in the just and necessary discharge of his or her duty. And that would be what that 3 in justifiable homicide is what would be struck from use in this particular case. And correct me if I'm wrong, Bryn, when a person under the sections regarding the restraints, improper restraints. And so it would not be a defense under 3 in an improper restraint. Is that correct? Is that as narrow as it would be?
That is correct. So if
Or is it broader? So
No, it would-
if a police officer uses an improper restraint, they would be able to use 3.
right, they would not be able to raise as a defense subdivision 3 of the justifiable homicide statute. And again, it would only be if the law enforcement officer used a prohibited restraint that caused serious bodily injury or death. What this language would do is it would exclude this defense under 23053 would not be available to a person being prosecuted under this new statute.
But the others, 1 and 2, would still be available.
That's correct. So justifiable homicide, that those defenses that are laid out in 1 and 2, and this 1 is essentially self-defense or defense of the person's relation would still be available. And the defense of I committed this act in the suppression of to suppress this person from committing a serious violent crime, that would also remain a defense for a person being prosecuted under the new crime.
So Bryn, if we adopt this amendment, wouldn't we have to change the reference in 219 that we voted out? Because now it says that there's no change to the availability of the defense in this statute.
So the amendment, draft 1.3, should replace that language that says it strikes that subdivision.
Ah, okay,
It says
good.
nothing in this section should be construed to limit or restrict the availability of that defense.
Okay, good.
Strikes
if
that
the-
out.
Just
And
so everybody understands, you may be on the committee and those who may be listening in. If we adopt this, a police officer who would use an improper restraint could use as a defense. He was suppressing a person attempting to commit murder, sexual assault, aggravated sexual assault, burglary or robbery with force or violence.
Yes, that's correct.
So basically the most serious crimes.
Well, yes, but we're missing a very major component of police responsibilities.
But Joe, it's when, just to remind ourselves, it's when a police officer uses an improper restraint that
Prohibited.
results in death or serious bodily injury to the person who was being restrained. So it's not if there's a riot.
And just to remind us, it's a prohibited restraint and it's illegal. So
Right.
they're breaking the law and injuring somebody. They still have these first 2 defenses.
Those first 2 defenses do not cover a situation if I am on the ground being kicked by a riotous mob and a police officer injects him or herself into that scene and uses whatever reasonable means are necessary, including a prohibited act, in order to stop me from being further kicked. Unless the demonstration is there that I am either being subjected to murder or sexual assault or burglary or robbery. Those first two provisions are very specific on how you can use a defense in that case. And what's missing is the ability of the officer to bring calm to a situation that doesn't fit neatly into that definition.
But Joe, if you think about the tools that are available legally to an officer to stop a riot, I mean, we've all seen television images from the last month and a half. There's a whole panoply of gear that is non-lethal, that is called out in the event of a riot. What we're saying is, if you see someone kicking someone, it is not proportional and it is illegal to go in and choke that person out and risk killing them. So, you know, what this prohibition, we prohibited these kind of restraints, and we're just making sure that C doesn't inadvertently open the door to using them in any, I mean, if you read C, it's about as broad as it could be. You could be serving a subpoena and you know, fall under this.
Philip, you and I agree, C is terribly overbroad.
Yep.
But let's take the case of a riot. There's a reason that word appears in C. It does not appear in, it's actually 1 or 2 under the statute. Justifiable homicide has 3 numerically designated paragraphs. It's the 3rd paragraph that you and I agree is overbroad and needs to be worked on. But the word riot appears there. It does not appear in the first 2 sections. So in my mind, as I'm reading that, if an officer steps into a riotous situation, they may need to use whatever force is necessary at that point. But it now, as society is changing its attitudes, it falls on the officer to demonstrate why it is they did what they did at that point. And I'm trying to reach the place where we don't strip police altogether of things that may need to happen that we all actually would agree needed to happen at that moment in time.
But Joe, the committee agreed 5-0 to prohibit these restraints. Now what you're arguing is that if we can construe something as a riot, they should be allowed to go in and choke whoever they want. And I'm not,
Philip, I'm not saying that. I'm saying that there is a very fine line between depriving an officer of a defense that currently exists because we're angry about the way that it has been applied.
No, that's untrue. Nobody's angry about the way it's been applied. We're looking at it now in the light of what's going on around the nation, which is peaceful protests with occasionally violence here or there. What this provision does is it doesn't even limit it to riot. It says civil process, civil procedure.
Philip, I agree with you completely that that is overbroad. It needs to be removed in this situation. But we haven't got to the point yet where we're talking about the 2 things now that an officer would have available as a defense. And those 2 things are very specific and limited. It says they can protect their own life or the life of a husband, wife, parent, child, brother, sister, master, mistress, servant, guardian, or ward. But the officer can't protect me in that situation.
But under the other one,
it says in the suppression of a person attempting to commit murder. Okay, I'm not being murdered if I'm being kicked and I'm on the ground. Or sexual assault, I'm not being sexually assaulted.
You could.
Or burglary or robbery, and I'm not subjected to either of those. So what we're saying is the officer can't even raise as a defense, Benning is being assaulted. I can't use the defense that I used some improper restraint to try to stop that from happening.
Yeah, first of all, remember that this is limited to the improper restraint. Second of all, it is only when serious bodily injury or death occurs as a result of that improper restraint that the police officer would be charged, right? So the mere fact of using it may result in disciplinary issues, but it wouldn't rise to the level of the 20-year felony. If the, and so while I understand your example, I was fairly comfortable with Matt's suggestion because I think, I mean, if we were using it broadly, that any use of force, etc., still, as Philip said, they've still got a number of different avenues. It's when they use an improper restraint.
A prohibited restraint, an illegal
Excuse me,
restraint.
right. Yes, thank you for, I'm still using the wrong term. I got to get my,
Yeah,
report.
I keep saying that because all of the other things, guns, pepper spray, different tools
tasers.
that we've heard about, tasers, pepper balls, all of those things are illegal and can be used under various circumstances. We're saying this one thing is illegal, but you still, if you cause bodily injury or serious harm because you're afraid of your own life, which was your concern, Joe, as we discussed it. Now you're broadening it to, if a policeman sees somebody being kicked, they need to be able to cause serious bodily injury by choking someone. And I think at that point, we've gone all the way back to where we started, which is police having the right to choke people when they feel it's necessary.
I don't want to reach that level. I'm trying to get to a middle ground that
Well,
enables an argument to be made.
I think
I don't think there's,
what the amendment
ahead.
now says, and Senator Sears has said, we'll look at C and take testimony later when we have time. What it does now is it prohibits C from being a rationale for using the prohibited restraint. But, you know, I think you and I agree C needs more work. I would be for striking it all together. Sounds like you would want some modification of it.
well, can I, you know, Joe, if you use the example of Kent State, National Guard, they were not police officers. They were the National Guard at Kent State, which was 50 years ago, which is indelibly marked in all of our minds who are older than 50, I guess. Maybe those of us who are 60 and can remember it. I suppose they could have said they were out to suppress a riot or rebellion and killed 4 kids. And under this justifiable homicide, they wouldn't have been culpable at all. And so I think in the narrow sense that we're using this, and that's why C needs to really be changed under Vermont law and needs to be addressed. And I've committed to taking it up Thursday and Friday. And I'm not sure we'll get through it all in the limited amount of time we have between now and the end of adjournment of the complete session. But I think that for the purposes of the narrow purposes of this bill, prohibited restraints, that portion of this bill, that I'm comfortable that 1 and 2 provide that. And also I want to point out that in the use of force bill, we talk about proportionality, the use of force being proportional. Those crimes in 2 rise to a level that a DUI or in the Georgia case, or a $20 counterfeit bill in the Minneapolis case would not rise to, where improper use of force or restraint in the Minneapolis case. So I'm just that's why I'm willing to support this. But you know, it's up to the whole committee. And if you'd rather not have your name, we can separate these 2 amendments out. So there's different names on the 2 amendments.
The overall concept of proportionality, I think, is very important here. When you use the analogy of Kent State, in hindsight, every one of us believes they were way out of line in what they were doing. How do you correct that behavior? When a cop walks up to a group of people on the street who are having a verbal argument and pushes one of them to the ground, to me, that's way out of line, totally unproportional to what was actually going on. We all agree to that part of it. There are situations, though, when we charge officers with keeping the peace, that there has to be some way for them to be able to present an argument that what they did was proportional to the circumstances. And at the end of the day, it is up to a jury to decide whether that is true or it is not true. And I'm nervous that we're approaching a point where our desire to correct wrong behavior is stretching out a little too far for me to be comfortable. Now, this particular amendment, I'm uncomfortable just depriving the officer of any way to make an argument unless it falls within the justifiable homicide language that all of us are normally entitled to. Because in that uniform, they are responsible for doing something you and I are not responsible for. And I'm troubled by extending
Peggy,
what we believe for us is
Excuse me,
beyond.
Joe, we've
Yeah.
lost the video. I don't know what's happened. Oh, there we are. We're back. Sorry, Joe.
That's
We're
okay.
having technical difficulties.
And I just got an email from someone saying the YouTube is not streaming, so I'm reaching out to IT to figure that out as well.
Okay.
Oh, it's
Well,
a recording button.
Matt Valerio has joined us, and I don't know if Matt's heard any of the debate or not, but would love to have your counsel.
I've heard some of it. I don't think I've heard it all. And what I heard is a little confusing, but I had concerns about, as you know, last week, this invoking justifiable homicide as part of the bill as well. But what I haven't seen, or what I'm not sure of, is what the amendment is. I see.
The amendment would strike 3. So a person who kills a police officer who uses a prohibited restraint, again, keep using the term improper, a prohibited restraint that results in death or serious bodily injury would be able to use 1 and 2 of justifiable homicide, but not 3.
And just to clarify, Matt, it doesn't strike 3. It just says it's not available in this case.
Oh, of 2305, it says that 3 isn't available
Yeah,
to an officer.
yeah.
Right.
Who uses
wow.
the prohibited restraint.
Wow, that's
Put yourself in the defense attorney's role for a minute and you're
Yeah,
facing a jury with that question in front of you.
well, I'll just try to put myself in an officer's position too, or in see the way the way justifiable homicide is written is 1 and 2 are for lay people, which could apply to anybody, but 3 is specifically designed for officers. You know, one of the things this really shows, and I think that Senator Sears, I know you're committed to doing this, but that justifiable homicide needs to be reworked seriously.
Okay, but
I don't know that.
I thought this was your suggestion, Matt.
Well, my suggestion was to leave justifiable homicide out of it and allow common
Okay.
law defenses of just, regular self-defense and the like to be part of it. I'm worried about how a court would interpret it if you left justifiable homicide in, but then did, but struck 3.
Matt, are you saying that we should think about just removing the reference to justifiable homicide altogether from 219?
Yeah.
That's what I was trying to get
Yes.
at last week, only because when you create a statute that puts limits on what your defenses might be, those are the defenses that I think that you end up having. I could see a court interpreting it saying, look, you used this. It'd be one thing if you use this technique, you know, to suppress one of these crimes that are listed here or in number 3. But if you did it and it didn't fit those specific categories, then now you've got a problem.
But as I read Bryn's email about that,
Yeah, I haven't had the benefit of that, but
Bryn, correct me if I'm wrong, but you thought there was a conflict between 2305-3 and what we were passing, and it was not clear which would take precedence.
that's part of it too. I mean,
Hey, can I just ask Bryn?
Yes, that's correct. I think that the two statutes stand in pretty stark opposition to one another. So I think an attorney could make an argument that 2305 would be effectively repealed by the new crime in 1032 if it's silent on whether or not that is available for a defense or not.
Well, if the options are to strike the reference to 2305 altogether, or the amendment that makes C unavailable, or to go with what Joe wants, I would take the first one, which is getting rid of the reference to 2305 altogether.
Mind you, what I originally proposed, which was the affirmative defense.
See, what I don't like
With
about
let me just finish with
Yeah,
the the onus is on the defense to prove that it was justifiable.
but I feel like then we're offering an affirmative defense that doesn't exist now for a crime that we're prohibiting. So we're at once creating a new crime and a prohibition and adding a defense that doesn't exist. So it's one step forward and half a step back. Whereas I think if we take Matt's suggestion and we eliminate the reference altogether, it accomplishes more what we've set out to do.
don't, you know, my understanding is anytime that you guys create a new crime, any of the common law defenses exist. So you can have a defense of self, defense of others, and you have the ability to respond proportionally to whatever the threat is sufficient to repel the threat at any given time. And I'm generally giving you self-defense type concepts. And I, you know, Bryn, do you disagree with that interpretation? Because that's what we do all the time, right?
I don't disagree with that. I think that my point was because the justifiable homicide statute exists with the specific subsection that deals with law enforcement, that there could be an argument made for implied repeal of that section if it was silent on 2305C or 3. And I'm obviously not taking a position on that. I was just pointing it out for the committee that.
Oh, I understand.
So if I could just summarize a little bit. So if we take out the reference, and this is to Bryn, if we take out the reference to 2305, then if there was a case where an officer used the prohibited restraint, caused serious bodily harm or death, there would still be a determination made by a state's attorney whether to charge. And wouldn't the state's attorney consider these sorts of issues, whether it was self-defense, et cetera.
Yes.
And then it would move theoretically to a courtroom where, again, there would be a consideration of these common law defenses or other defenses available in statute.
Right, presuming the defense attorney raised the defense, yes.
Yep. So if we're silent on 2305 in 219, it doesn't leave someone who uses the prohibited defense without a legal defense. They still have multiple possibilities of either not being charged or being acquitted. It's just that we're not offering them a helpful defense in the form of an affirmative defense.
I think that's correct. All the common law defenses would still be available. I think that the justifiable homicide statute would still be available. The question I had was whether or not that specific part of the justifiable homicide statute could be seen as an implied repeal by the legislature based on the new language.
And I would be fine if it was seen that way, because the 2305(3) seems to me, I mean, it was put in place in the 80s and it was a different time. But when you look at it now, it's so broad, I can't see how you could ever convict a police officer. It basically immunizes them from almost anything.
And it may not. A court may decide that there is no implied repeal, and it may just be considered a defense to the.
They may listen to this conversation.
What's that?
The court may listen to this conversation in terms of legislative intent.
Yep.
I still think that I won't. So the choices are to not have a Second Amendment to this bill, not to the Constitution. Well, you know.
Oh, everybody wants to hear it.
Right, just in case. Or to go with the suggestion, or to go with an affirmative defense. Senator Baruth has been adamant against an affirmative defense. I've been supportive of it because I think it solves all of these problems we've just talked about, but I'm flexible here. I have committed to working on 9025, the justifiable homicide statute. I think that this has highlighted, this particular conversation has highlighted the need to revise this. And frankly, if we're in a riot, I don't know what the justification is to kill somebody, to suppress a riot or rebellion. I mean, I just don't. I need to hear more about that, and why in 1983. That was an amendment in 1983, and I don't know what that amendment was, Bryn. But the bill, the law is obviously from much earlier.
So
the use of the term master and mistress and ward certainly is and servant is from much earlier than 1983, I'm sure.
I think that's right. I haven't been able to get into the building, look at the to look at the actual books, because I've got to look at the books in order to.
I would guess that there was an amendment made in 1983 for whatever reason, but that the law itself is probably from maybe even the 1800s.
Yeah, that may be.
Senator Baruth.
So Dick, given what we've said, I would move that we adopt the intent language and rewrite the Second Amendment so that it strikes the reference in 219 as passed to the 2305 piece altogether.
Okay. Does everybody understand Senator Baruth's motion? With that, I think I'm just gonna Okay,
Would
Senator,
you-
what,
I
Nitka?
have an
Yeah.
explanation of that by-
Just make sure that I understand it. So what you're
Okay.
saying is that we will get rid of any reference at all to any defense.
Yes.
Oh, well, yeah, justifiable homicide.
Right,
The
right,
only,
but I
the
mean,
only thing that was in the bill was a reference to 2305 justifiable homicide. Senator Baruth's amendment would strike justifiable homicide, that reference from the bill, and then add the intent language.
It would strike the reference from the bill, but it would leave the statute as it
Leave the
stands.
statute as is.
Right.
right, and not put in Senator Sears.
None of my wonderful suggestions would go in.
Right.
I thought your suggestion was wonderful.
Thank you.
I actually think that I'm throughout this whole conversation have been a little nervous about kind of that we're maybe even overreacting. And I don't think that there's anything justifiable about somebody doing some of the horrific things that we've seen, but I'm nervous about some of the things that we are doing. And I guess we'll just see what happens. I'm sure will be cases on them, and we'll see what happens.
I appreciate that. I want to make clear, I'm not nervous about what happens as a result of us prohibiting certain restraints.
No,
They've been outlawed. I heard New York City had outlawed them in 1987, yet somebody's accused of using one yesterday. So, that it's something that I just don't see as somebody, as I've said earlier, and both Senator Nicker and I were trained in restraints. I don't see this as such why anybody's using them is beyond me. And why, kneeling on somebody's neck is considered a form of restraint. That's even necessary. So when it's hard, so I'll support the amendment from Senator Baruth, or the motion from Senator Baruth. Even though I still think that, so with the understanding that we will look at 2305 justifiable homicide. But I don't know, given the short period of time we have left, where it goes.
So I wonder, could we hear from Matt on where that leaves a defense for a police officer? What are you had said the common law ones would still hold up?
But I think so. I mean, that's what typically happens, is that, you always have self or others, but your response has to be proportional to whatever the threat is. You can't, like they say, you can't bring a gun to a fist fight, right? If you're involved, if you're confronting a fist fight, you have to respond with some kind of non-deadly force in response to that. If you are confronted with deadly force, you have the right to meet it with deadly force. That is still available. What I don't think you can do is, you have a DUI stop, and as you're chasing the guy away, you can't shoot him in the back. That's not, that's again a completely different thing. And as it relates to your restraint issue, you've outlawed a particular type of restraint. And the question is, what does it do to that? And I'm not exactly sure, what circumstances would rise to the level where you would have to use that kind of deadly force.
Say you're fighting over a gun.
Something like that. I mean, that'd be That'd probably be the only kind of thing. It couldn't be for, I mean, the things we're seeing are not, they aren't people being confronted with guns. They're $20, bad bills and DUIs and that kind of thing.
Isn't that the sum and substance of the argument in front of us? Proportionality seems to be the whole conversation. We all know what's way out of line. And it's that gray area in between that people get frustrated about. And I'm not sure I want to leave a record that suggests we are getting rid of 200 years of jurisprudence in the attempt to react to what we're seeing on the news these days.
How are
I
we
think-
getting rid of 200 years of jurisprudence?
Well, if we leave any piece of this record as suggesting that we are repealing the language in justifiable homicide, that
That's
would
from
be,
1983, Joe.
we don't
it
know
does.
exactly what the 1983 provisions were at this moment in time. My concern is you have a very long history of common law, which has presented a jury with what is proportional under the circumstances. They have to listen to that and make a decision. And I know there's frustration about some police officers getting away with something they shouldn't have gotten away with. But I don't want to leave the record on voting with this, that we're suggesting we're trying to repeal that ability of an officer to make a defense that is correctly proportional to what happened under the circumstances.
No, what Matt is saying is if it is proportional, there is a defense.
Well, I agree with him 100%, and I'm hoping to leave that as part of this record going
I
forward.
think if you read S119 and S219 together, you would see a record of looking at proportionality in the use of force. And we're prohibiting in S219 a certain use of force that has been proven to be deadly or provide or create serious bodily injury. And so we're not. So I don't see as our commitment to continue to look at justifiable homicide statutes as being anything other than a serious need to update anything that in this day uses in our laws terms like master, servant, and mistress as being something that's akin to Vermont in 2020 versus Vermont in 1810. So I don't see a commitment to look at a law that's long overdue for revision as being something that undoes a defense to anyone, whether they be a law enforcement officer or a state senator or a citizen of the state of Vermont.
Dick, I think you rightly pointed out that somewhere down the road, a court will be looking back at this record to
Well,
decide what
yep.
our intent was. I'm merely saying that if I vote for this amendment and the bill itself, I am doing so with a clear understanding that we are not intending to repeal anything at this point in time.
Right.
And that whatever defenses have been traditionally raised can still be raised.
I believe in the right for people to defend themselves.
And could I just,
Oh, go ahead, Jeanette.
well, I don't think, I'm not sure what will happen when we look at that justifiable homicide section, but in my mind, I have no intent to repeal it, but to update it. I mean, I don't think that is our intent, right? Is to repeal that at all, but to
No,
look
but
at what it means now and how it should be written and interpreted.
But on the anniversary, well, I will go a step further though. On the 50th anniversary of Kent State, I think we ought to be darn clear about your ability to shoot people because they are protesting. or
Yeah,
rioting.
yeah,
Right.
I agree, but I do think that if courts are looking at our intent and I think that we need to make it clear that our intent is not necessarily to repeal, but
Right.
to
Well-
look at it in terms of what we need
Uh-huh.
now.
I hope,
I have no intention to repeal that.
my hope is that none of this ever happens.
Yeah.
That police officers will not use the prohibited restraints under any circumstances and will not, we won't have serious bodily injury and death as a result. So I'm ready to vote. Peggy, the Senator Bruce's amendment, could you please call the roll unless there's further discussion?
Let me just ask Bryn, can I just ask Bryn something? So Bryn,
Sure.
with regard to the issue of the officer and a person are in a fight over a gun, if the officer uses one of the prohibited restraints, he still has a defense.
Oh, I think that would be a pretty clear self-defense case.
Okay,
Yes.
thank you.
So I just want to make sure this is draft 1.3 you're talking about, right?
Draft 1.3 as amended, when the amendment would be to take out any reference to justifiable homicide in S219.
It will just be striking subdivision C in section 5.
Okay,
And adding intent language.
Bryn, are you going to do like a new version that would be 1.4 that would have all this stuff, or we're voting on 1.3?
You'll vote, it'll be 2.1.
So, okay, so we're going to vote on 2.1, not 1.3, correct?
Correct.
Okay.
So let me get this clear. In this version, we're taking out the second proposal of amendment, right?
Yep.
Which
And
refers to,
And we're revising the second proposal of amendment to take out the reference to the law on justifiable homicide.
right, but then you don't need it in there at all. Well, anyway, okay.
Well, you need to
Well, you
get
have
rid
to
of
take
it.
it out because
in
it's in the
219.
version that's on the floor.
The whole Second Amendment is in the version that's on the floor? I don't know what's on the floor.
So what we voted on Friday had a reference to 2305.
Yes,
So this updated amendment would strike that reference in 219 as we passed it on Friday.
right. Okay,
Everybody clear?
yes.
Any further discussion? And I understand the technical difficulties and I hope that the YouTube recording is running and
It is.
all that.
It is running.
Okay,
Yep.
so this is an amendment actually from all of us. Is there anyone who wants their name off the amendment, by the way?
I will on it.
On it, off
Yeah.
of it. It's already on it.
Everybody's on. Does anybody want to come off?
Does anybody want to take their name off? That's the question. All right, Peggy, would you please call the roll?
Yes. Senator White,
Yes,
Senator Baruth,
Yes.
Senator Benning,
Yes.
Senator Nika,
Yes,
Senator Sears.
Yes. So Senator Baruth will take care of the amendment as soon as he gets it from Bryn. Send it to John Bloomer. It'll be in tomorrow's calendar when we report S119 and S219. Senator Baruth will report 219. I'm reporting 119. I don't know who comes first.
I don't know. It's up to
I don't know
Bloomberg.
that it
whoever's on
matters.
second.
I know they're
I knew
on
you were going
third.
to say that. I knew you were going to say
think-
that.
They're on third. So we'll see you all later this afternoon, I guess.
so could
Do
we,
we have a session at 3:30?
Yes,
yes, today,
Oh.
and it's
Okay.
going to go forever.
could we get a
Wow.
copy of the amendment that we just did, please?
Yes,
I'll send it to all of you right now.
Thank you, Bryn.
Bryn's already written.
Yeah.
Bryn's so far ahead of us.
Okay,
And we're
Matt,
meeting
thank
tomorrow
you
at,
for your
Oh, sorry.
counsel.
Thank you, Matt.
And,
we're meeting
I'm
tomorrow.
off for a 2-hour dentist appointment.
Oh,
oh
no.
my God,
Right now? Ooh,
We're on tomorrow at 10:30, right?
no.
10:30 or 15 minutes after floor ends.
Okay.
I'm not, we're not sure how long will go on. We've only got Eric as a witness, so
Yep.
hopefully he can sit at home and rest until we're available.
Yep.
We're
Thank you.
We're taking up the deeds issue, and I'm sure you're all looking forward to hearing from the St. Albans probate bar, which is on Wednesday. And Joe,
May I
just be prepared.
May I ask you a question, Senator Sears? Did you hear
Yeah.
back from the House at all about the rape kit testing?
I have not, but I have heard the good news is that the House Judiciary and Health Institutions Committees have agreed with our amendments to S 338, so it'll be on its way to the governor.
Oh, good.
Great.
Good.
Thank you.
All
Yeah,
right.
no, that's really good. I mean, that's an important bill.
Yeah,
That Bryn, take a deep bow on that one for all the drafting and work you did on that. It is true beginning, it's really important of the justice reforms that we can do in terms of the criminal justice system.
That's great.
So good work, everybody.
Yep. All right, I'm gonna end now.
See you
Thank you.
later.
See you guys
Bye.
tomorrow.
See you in 3 hours, some of you 2 hours.